Hi guys, today we'll be discussing key legal developments for the month of February 2022. As you all know, Clat is just about there, and at this point of time your preparation with respect to current legal affairs, with respect to your current general knowledge matters a lot. So this is supposed to give you the key legal events that happened in February 2022 so that you at least know that these are the broad areas you need to look into if you want to do a more thorough holistic preparation. With that note in mind, we'll continue with our presentation. Again, this is not supposed to be an exhaustive inquiry. All I'm doing right now is giving you the broad events that you need to cover. Over and above that, any preparation is appreciated and welcome. So we'll get started. So recently the Supreme Court has held that consumer complaint against telecom companies are maintainable in law. So उसमें the issue was, often the issue arose that telecom companies would say कि हम consumer protection act में cover नहीं होते हैं क्योंकि we have our separate body governing us. एक एक्ट है इंडिया में, टेलीग्राफ एक्ट है 1885 का. तो जितनी भी बॉडीज होती हैं जो टेलीकॉम सर्विसेज प्रोवाइड करती हैं या फिर बॉडीज विच प्रोवाइड इन सम नॉट इंटरनेट सर्विसेज बिकॉज दैट इज नाउ कवर्ड बाय आईटी रूल्स, बट टेलीकॉम कंपनीज अक्सर ये कहा करती थी कि हम टेलीग्राफ एक्ट से कवर होते हैं. यदि आपको हमारे खिलाफ कोई शिकायत है तो आप वो टेलीग्राफ एक्ट ऑफ 1885 में जाके करें. उसमें सेक्शन 7B है, उसमें आर्बिट्रेशन का प्रोविजन है. तो अभी उसमें सुप्रीम कोर्ट के जजमेंट्स भी थे जिसमें सुप्रीम कोर्ट ने बोला था हाँ बात तो सही है, इफ यू हैव अ कंप्लेंट अगेंस्ट द टेलीकॉम कंपनी देन यू गो अंडर सेक्शन 7B फॉर आर्बिट्रेशन. बट रिसेंटली द सुप्रीम कोर्ट हैज चेंज दैट पोजीशन ऑफ लॉ. सो व्हाट इज द पोजीशन ऑफ लॉ नाउ? The position of law is that you, the consumer, cannot be compelled to choose a remedy. ऐसा नहीं हो सकता कि आपको टेलीकॉम कंपनी फोर्स करे कि नहीं पहले आप टेलीग्राफ एक्ट में जाओ, मेरे खिलाफ कंज्यूमर एक्ट में मत आना. जो हमारा नया कंज्यूमर एक्ट है 2009 का, जो पुराने कंज्यूमर एक्ट है जो 1986 का था, ये उस पर एक इम्प्रूवमेंट है. ये उसका एक नया वर्जन कह सकते हो आप, वो है जिसमें कंज्यूमर लायबिलिटी का जो प्रिंसिपल है उसको काफ़ी एक्सपैंड किया गया है, उसको ज़्यादा कंज्यूमर फ्रेंडली बनाया गया है. तो एक्ट की स्कीम को ध्यान में रखते हुए, उसका नेचर, उसका ऑब्जेक्टिव ध्यान में रखते हुए सुप्रीम कोर्ट ने होल्ड किया है कि इफ़ यू हैव अ रेमेडी, इफ लेट्स से यू आर डिससैटिस्फाइड बाय द सर्विस योर टेलीकॉम मैन्युफैक्चरर इज योर टेलीकॉम सर्विस प्रोवाइडर इज प्रोवाइडिंग टू you, then you can file a complaint alleging deficiency of service against your telecom service provider, and that would be maintainable under law. The telecom company would not be able to say that you go under Telegraph Act against me and do not use your consumer remedy against me, because the Supreme Court has held that the consumer cannot be compelled to choose one remedy over the other. Both remedies are parallelly used and both are equally important. So this was the question that was up before the court, whether the issue involved was whether the provisions of the Telegraph Act of 1885, which is the original law, oust the jurisdiction of consumer forums. So under consumer law we have three forums. We have a district forum, we have a state forum, and we have a national forum. Again, their jurisdiction varies. The jurisdiction is pecuniary. Pecuniary jurisdiction मतलब हर forum का jurisdiction उसके पैसों से कि एक हर उनके पैसों की लिमिट है कि इतने लाख से इतने लाख का केस डिस्ट्रिक्ट फोरम में जाएगा, इतने लाख से इतने लाख का स्टेट में, और फिर करोड़ों का नेशनल फोरम में. सो दिस वाज द क्वेश्चन कि यदि टेलीग्राफ एक्ट में आर्बिट्रेशन का प्रोविजन दिया हुआ है आपको किसी टेलीग्राफ अथॉरिटी के लिए, तो क्या आप कंज्यूमर एक्ट में उसके खिलाफ कंप्लेंट कर सकते हो? एंड देन द सुप्रीम कोर्ट हेल्ड दैट द रेमेडी अवेलेबल अंडर सेक्शन 7B of the 1885 Act, which is the Telegraph Act, and that available under the 2019 Act, which is your Consumer Act, are parallel remedies and the consumer cannot be compelled to exhaust one before the other. कंज्यूमर को आप फोर्स नहीं कर सकते कि आप एक रेमेडी लो दूसरी मत लो. कंज्यूमर दोनों में से जो चाहे वो रेमेडी अवेल कर सकता है. ऑलराइट. हाँ, सो अभी न्यूज़ में एक बहुत हिजाब बैन का इशू बहुत आ रहा था, राइट? आई एम श्योर इफ यू हैव बीन फॉलोइंग द न्यूज़ यू नो दैट देयर वाज व्हाट वाज कॉल्ड अ हिजाब बैन इन प्लेस. देयर वाज बेसिकली अ गवर्नमेंट ऑर्डर. सो एक गवर्नमेंट ऑर्डर था कर्नाटका गवर्नमेंट का 5 फरवरी 2022 का. उस ऑर्डर से उन्होंने क्या बोला था? उस ऑर्डर में उन्होंने कॉलेज डेवलपमेंट कमिटीज जो कर्नाटका में एस्टैब्लिश्ड हैं, उन्होंने उनको बोला था कि देखिए वी हैव दीज रूल्स कॉल्ड Karnataka Educational Institutions Classification, Regulation and Prescription of Curricular Rules of 1995. ठीक है, तो उन्होंने बोला था कि see we have these rules of which Rule 11 says that all public educational institutions have to have a student uniform. ठीक है, so they said now you make a student uniform mandatory. Now you make a student uniform mandatory in terms of Rule 11. And then in furtherance of that, certain public educational institutions had, not for everyone, for students attending those educational institutions, said that you have to abide by the college's uniform and you cannot wear religious clothing. You cannot wear religious clothing. So this issue evoked a lot of response in our media and otherwise. So the issue was that if you have the freedom of religion under Article 25 of the Indian Constitution, so Articles 25 to 28 guarantee you freedom of religion under the Indian Constitution of varying sorts. So Article 25 says that you have a right to practice, you have a right to your conscience, which means that you have a right to believe as you feel. You have a right to practice your religion, the rituals involved in it. You have a right to profess and you have a right to propagate. These are the 4 rights that Article 25 guarantees you. So a bunch of Muslim students, Muslim female students, moved the Karnataka High Court against the ban, saying 2 things. First, that if I have a right to practice my religion, then I have a constitutional right to wear a hijab because it is essential to the practice of my religion. We'll get to that. Something called essential religious practice. Okay. This was their first argument, that I have a right to practice under Article 25 and that is why it is protected. And the second argument that they took was, I have a right under Article 19 itself. I have a right to express myself as I feel, and this wearing of a hijab, of a headscarf of various natures, is my way of expressing my personality, my personhood, and that is a right protected under Article 19 of the Constitution. Now, the way the law has been laid down by the Supreme Court is that Article 25 protects your right to practice your religion, only protects essential religious practices. So for a particular practice in your religion to be protected under Article 25, you have to show that it is an essential religious practice for your religion. Now this was the issue which was involved in these petitions. So what has happened now? The Karnataka High Court has reserved its judgment on this hijab ban, which was following the government order dated 5th of February. In this government order, the government had also said that wearing of a hijab is not essential to the practice of Islam. So again, the hearing went on for 11 days. The case was heard before a full bench of the Karnataka High Court. Full bench meaning 3 judges. If it says full bench means 3 judges. A full bench of the Karnataka High Court comprising who? The Chief Justice himself, Rituraj Avasthi, Justice Krishna S. Dikshit, and Justice J.M. Khazi. They reserved their judgment on these bunch of petitions which challenged this so-called hijab ban, challenging the hijab ban imposed in public educational institutions by the Karnataka government. This case is called Srimati Resham and another versus State of Karnataka and others. What does reserving of a judgment mean? It means the court has heard the matter. It is now contemplating it and it will come out with its judgment on a later date. It has reserved its judgment. The arguments in the case are over and now the judgment will be pronounced on a later date. On a later date. So hearing in this case went on for 11 days, quite exhaustive hearings. And what was the question involved? The question involved was whether wearing of a hijab, the headscarf, is an essential religious practice in Islam and protected under Article 25 of the Constitution of India. This was the issue. Now we are all awaiting judgment and let us see what the judgment is. Once the judgment is out, we will also cover a video on that. Alright, so with this, just know this, that the Constitution protects essential religious practices only. Your right under Article 25 protects essential religious practices only. So for hijab, wearing of a hijab to be protected under the constitution, the Karnataka High Court has to hold that wearing of a hijab is essential religious practice. All right. Now, another judgment in the area of gender equality was given by the Supreme Court recently in this case called Hotel Priya, a proprietorship versus State of Maharashtra and others. Now, what was in question here is that there is something called the Maharashtra Police Act of 1951. Under the Maharashtra Police Act of 1951, they've made these rules called the licensing and performance for public amusement, including cabaret performance, melas and tamashas rules of 1960. Now, under these rules, the Commissioner of Police of Mumbai, the Commissioner of Police of Mumbai had the power to give licenses to orchestra bars containing terms and conditions about how that orchestra is to be performed, okay, how those performances are to be made. In one such license which was issued to Hotel Priya, the condition was that you would have 4 male performance artists and 4 female performance artists on the stage only. So Hotel Priya moved the court asking that this is an unconstitutional condition. Why? They said that the rules of 1960 do not require this. The act under which the rules are made, the Maharashtra Police Act of 1951, does not require this. And in our constitution, we have something called Article 14, which says that people have to be treated equally. And Article 19(1)(g) of the Constitution, which says I have a right to practice my profession as I see fit, subject to reasonable restrictions. So they said that saying that only 4 men and 4 women should be there, not more, not less, that is a gender-based restrictions, and that is violative of the mandate of Article 14 of the Constitution. And it is violative of, if I want to be on the stage but your restrictions are prohibiting me from being on the stage because of my gender, that is also violative of my right to practice that profession under Article 19(1)(g) of the Constitution. So the Supreme Court held in this case that such conditions which restrict your right to participate in something based on your gender only, like how this license said that only 4 men and 4 women can be on the stage, that is violative of your right under Article 15. The commissioner is a part of state, right? State is defined under Article 12 of the Constitution, and it includes anyone who is also an instrumentality of the state, which the commissioner is. So it said that the commissioner, when he was discharging this function, should have kept in mind the mandate of Article 51 that the state cannot make distinction between groups of people on the basis of, among other groups, prohibited grounds of discrimination of sex alone. And this is a sex-based discrimination, a gender-based discrimination, and that is why it is unconstitutional. And it is also unconstitutional because if somebody wants to practice a profession, they cannot do that. Why? Because your license will prohibit them to do so. So the Supreme Court held that such conditions which are imposed in orchestra bars for to play orchestra music, they are violative of the Constitution and bad in law because they are violative of Article 15 and 19(1)(g). और इसमें एक और इंटरेस्टिंग बात है कि सुप्रीम कोर्ट ने इसमें होल्ड किया है कि कोई भी अगर ऐसी रिस्ट्रिक्शन होगी जो कि हिस्टोरिकल प्रेजुडिस में रूटेड हो या जेंडर स्टेरियोटाइप्स में रूटेड हो या फिर पैटर्नलिज्म में रूटेड हो. पैटर्नलिज्म यानी व्हेन समबडी थिंक्स दैट दे कैन गवर्न योर लाइफ बेटर देन यू योरसेल्फ. That is paternalism, when somebody acts like your dad, basically. So the Supreme Court held that ऐसी कोई भी restriction जो 1 या तो historical prejudice में rooted हो, 2 gender stereotypes में rooted हो, या 3 paternalism में rooted हो, they have no place under the Indian Constitution and they will also be held unconstitutional. Alright, so it's a landmark judgment. We'll move on to the next one. So the Uttar Pradesh government withdrew notices that it had issued to anti-CAA protesters. Now, as you would be aware, in February of 2020, there were a lot of protests, both pro and anti-CAA, and the Uttar Pradesh government had, among other things, issued notices under its through the additional district magistrate, seeking that because there's a judgment of the Supreme Court called in re destruction of public property, in which they'd given guidelines about how to recover money. Okay, I'll just put it down here. There's a 2018 judgment of the Supreme Court called in re destruction of public property. In this case, the Supreme Court had set down guidelines about how to recover money from those rioters and protesters who caused damage to public property. So you have a right to protest under the Indian Constitution, but you do not have a right to damage either public or private property, right? Obviously. So in furtherance of this judgment, the Uttar Pradesh government had issued 274 notices to CAA protesters, anti-CAA protesters, seeking recovery of damages for the public property damage during the protests. Now, the Supreme Court criticized the Uttar Pradesh government for the issuance of these notices. Why? It says that you've issued these proceedings under executive orders, under which claims have to be made by the additional district magistrate. तो आपने जो notices issue करवाए, या आपने ADM के through issue करवाए, जो आपके additional district magistrate हैं, आपने उनके through issue करवाए. ADM जो होता है वो एक executive authority होता है. ADM के पास कुछ judicial functions होते हैं, but primarily the ADM is an executive authority. So he said that this is in violation of judgments. Specifically, the Supreme Court said that issuance of such notices to anti-CAA protesters is in violation of our judgment in 2018 and otherwise. Why? Because in those cases, those judgments, those notices have to be issued and adjudicated by independent tribunals who are presided over by judicially trained persons. जो ADM होता है, ADM is a civil service officer. The ADM is not a judicial officer. So the Supreme Court had criticized the UP government for saying that you are acting as all three. You are being the complainant also. तुम complain भी कर रहे हो, तुम उस complaint को prosecute भी कर रहे हो, और उसका फिर नतीजा क्या होगा वो भी तुम खुद ही decide कर रहे हो. So the Uttar Pradesh government was criticized for this practice of issuance of these 274 notices by the ADM. Why? Because the ADM under the Supreme Court judgment could not have issued these notices. They could have only been issued by an independent tribunal presided over by judicially trained persons. And the Supreme Court had said that you are acting as the complainant, prosecutor and adjudicator, all three in this case. So the Uttar Pradesh government, after criticism from the Supreme Court, withdrew these notices, these 274 notices. And the matter in which all of this happened is called Parvaiz Arif T2 versus State of Uttar Pradesh. Alright? Great. We'll move to the next one. Now, Karnataka High Court has struck down a law banning online gaming with stakes. So, if you are aware, there's a lot of these online services now, online gaming platforms now, like A23 Circle, Rummy Circle, and other bodies which allow you to bet money on card games and otherwise on online games through, and your during IPL, all of those services come, no, wherein you can create your teams, your dream teams, and make money. So all of those practices, their constitutionality keeps coming up for challenge, whether that is valid under law or not. So now recently the trend is the Punjab and Haryana High Court and the Kerala High Court has held that, see, if somebody has a right to practice a profession, the state cannot. The government's argument is, see, we do not want people to lose money on illegal betting and gambling, and the law in this case is that as long as something requires some skill, that is not gambling, that because it requires skill, and that is allowed under law. So recently the Karnataka High Court has struck down a ban that the Karnataka government had introduced through the. So Karnataka government ने क्या किया था, उन्होंने कर्नाटका पुलिस अमेंडमेंट एक्ट ऑफ 2021 पास किया था, जिसमें उन्होंने बोला था कि कोई भी अगर ऑनलाइन गेम्स पे आप पैसा लगा रहे हो जिसमें स्टेक्स हों तो वो बैन हो जाएगा. उसमें सजा क्या बताई थी उन्होंने बोला था आपको उसमें मैक्सिमम 3 साल की सजा हो सकती है और 1 लाख रुपए का फाइन लगाया जा सकता है. तो कर्नाटका हाई कोर्ट ने बोला कि देखो, दीज आर नॉट जस्ट गेम्स ऑफ चांस, दे आर गेम्स ऑफ स्किल, एंड बिकॉज they require some amount of skill to be exercised, and because the state cannot take this paternalistic approach. I told you what paternalism is. It is when the state thinks it can make your decisions for you. So the Karnataka High Court held that these rules, the new Amendment Act, which banned betting on online games with stakes, that is ultra virus the Indian Constitution and thus quashed the amendment, set it aside. All right. Now, an interesting issue that is now coming up, and because it is so close to your CLAT timeline, I think is sort of relevant. Maybe there may be a passage on this. Is that this is the question that has come up? Ki jab there's something called, just know the article number and what it means. There's something called Article 142 of the Indian Constitution, under which the Supreme Court has power to do complete justice. तो सुप्रीम कोर्ट पार्टीज के बीच में जस्टिस प्रिवेल करे ये इंश्योर करने के लिए कैसा भी जजमेंट या ऑर्डर पास कर सकता है. ठीक है. तो अभी ये इशू सुप्रीम कोर्ट के सामने आया है कि अगर कोई जज एसबी में बैठा है, अकेला बैठा है, सिंगली बैठा है, सिंगली मैटर सुन रहा है, तो क्या वो ऐसी डिक्री पास कर सकता है डिवोर्स की जो कि म्यूचुअल कंसेंट से हो. तो अगर कोई जज के सामने आप सेपरेशन अग्रीमेंट पेश करते हैं, तो कैन द सुप्रीम कोर्ट अंडर एक्सरसाइज ऑफ इट्स पावर्स टू डू कंप्लीट जस्टिस अंडर आर्टिकल 142 annul that marriage on the grounds of mutual consent. So there are conflicting judgments on this. Some judgments have said yes, some have said no. The issue is the Supreme Court rules of 2013, which say that for such cases, in such cases, the power to do complete justice can only be exercised when the court is sitting in division bench, which is 2 judges. So 2 judges have to sit for annulment of marriages in these cases. So the issue involved is, क्या अगर कोई जज अकेला बैठा हो, अकेले मैटर्स सुन रहे हो, तो क्या वो एक मैरिज को अनल कर सकते हैं क्योंकि पार्टीज ने आपस में कंसेंट कर दिया कि हाँ आप हमारी मैरिज को खत्म कर दो. ठीक है. एक साइड जजमेंट्स की बोलती है हाँ, दूसरी साइड बोलती है नहीं, क्योंकि उसके लिए एटलीस्ट 2 जजों का बैठना है अनिवार्य है, उसके लिए 2 जजेस को बैठना पड़ेगा. सो दिस इशू इज नाउ रेजिंग एंड इट इज वेरी क्लोज टू योर क्लैट टाइमलाइन. आई थिंक यू शुड एटलीस्ट ब्रॉडली बी अवेयर ऑफ व्हाट आर द रूल्स इन्वॉल्व्ड. आर्टिकल 142 सुप्रीम कोर्ट रूल्स ऑफ 2013, एंड द इशू इज, कैन अ जज by mutual consent of parties annul a marriage while sitting singly, while sitting by himself in under its powers under Article 142 of the Indian Constitution. So guys, these were the broad updates on the legal profession that happened during February. From a CLAT perspective, you do not need to know a lot of detail about these. You do not need to know a lot of details about other things, because this CLAT, as we've established, is a comprehension based exam. But the idea of this session and of other such videos is to familiarize you with the broad concept, so that if you come across it on your exam, you're not taken aback. The unfamiliarity goes away, and I hope this session has achieved that purpose. And with that, we will wrap this up. I hope to see you again in the next video. Thanks.